Hello, everyone. Welcome to the latest episode of Drug Development Diaries. In this series of podcasts, we are discussing different chapters written in a book that we recently published called Approved: The Life Cycle of Drug Development. In this book, we discuss various aspects of drug development from design to clinical trials to manufacturing and biologics and also intellectual property. And many different facets are covered. Uh, in this series, we are inviting authors of all these chapters as guests, and we are having a candid conversation with them about their writing experience, about how they have structured these chapters, and what are their thoughts on latest developments in these fields. So, in today's episode, we have Joanna Brougher, and as usual, Dr. Naren Chirmule is our co-host in this podcast. So, I request Naren sir to take up the episode from here, introduce our guest for today, and get the episode going.
Thank you, Vihang, and welcome, Joanna. So I met Joanna, I think probably 5, 6 years ago now, when we were
Before COVID.
before COVID. Yes, before COVID, when we were working together on some project, and then one thing led to another, and I think that project's gone far different ways, but we've kept in touch in so many different ways, and so it's been a joy learning from you also and talking to you all these years. So Joanna comes with a very interesting background on through intellectual property with a undergrad in microbiology, immunology, so solid background in biological fields, and also a master's in public health, which is such an important element of drug development overall, and then law from Boston College. And over the last 17 years has been the practicing the art and science of intellectual property. But I also got to know her much more when she's been teaching at universities like Harvard and Cornell and UPenn. So both of us have been teaching at this UPenn course, and sometimes she joins mine and I join her course, and it's been really rewarding to meet students in that regard. So with that brief background, welcome to the podcast, Joanna.
Thank you very much.
Yeah. So let's get started with some basic questions. Intellectual property is an integral part of drug development. Maybe you can talk to us a little bit about why intellectual property is so important for when we have drugs, when we have to make drugs.
Oh, intellectual property is super important, especially in the biotech and pharma spaces when it comes to developing drugs, but also it's very important in almost any other technological field. So, as I'm sure you're aware, that there are several types of intellectual property when we generally talk about it. Patents are probably the most important. They're the ones that kind of come to mind when we think about drug development. And on the patent side, you get 20 years of protection with that patent. And that 20 years of protection gives you basically freedom from having a competitor try to challenge you and enter your space. And why is that important? Well, as you know very well, because you teach it, help in my class and in your classes as well, that it takes a really long time to bring a product to market in this space. Anywhere from 10 to 15 years is a reasonable amount of time that a company may spend developing their product, putting it through the regulatory clinical trials, and then hopefully getting it approved and onto the market. So by the time these companies are done with getting their product approved on the market, they may only have a few years of that important 20-year patent term remaining. And in that remaining time, they have to really recoup all of their expenses, which are quite substantial. Some estimates put it at several $billions a year at this point. And they only have a few years to recoup those expenses. And they recoup those expenses in order for them to be able to fund new innovation and continue this whole cycle. So patents are, first and foremost, kind of number one, what I tend to work with and what I focus my classes on. We also have trademarks, and trademarks can protect the brand or, the front-facing image of a company. And it's ultimately, when we think about like United, the airline, United, we all know the United logo. Same with Coca-Cola. That logo has been around for a very long time. Everyone knows when they pick up a bottle with this red mark on it with the white squiggly Coca-Cola, they know what they're drinking. And same applies in the drug development field. Every company has a trademark associated with it. Every drug has a trademark associated with it. And companies do spend a lot of time and energy protecting those valuable marks. We've heard a lot about trade secrets too. Trade secrets are slightly different. Coca-Cola is probably the classic example of a trade secret. Nobody knows the formulation for Coca-Cola. It has been around for over 100 years at this point, but nobody knows what that formulation is because it's a trade secret and it's protected as long as it remains a secret. Once somebody divulges that very famous formulation, anyone can go ahead and copy that secret sauce and make their own versions of Coca-Cola. But if it continues to stay a secret, then that formulation is protected. So these are the ones that come up quite frequently in the biopharma space. And trade secrets in particular is an interesting one because a lot of development, especially on the biologic side, really comes down to the manufacturing processes behind these drugs. And a lot of companies tend to wonder if they should protect these manufacturing processes via trade secrets or to go ahead and file patents on them. So there's a lot of debate on that issue. I tend, as a patent attorney, I tend to focus on patents, and I still think there's great value in filing patents on those manufacturing processes, but certainly some people will disagree with me.
Yeah. So I think the follow-up question on that was, in terms of, especially because for startups and entrepreneurs who are starting off their careers in terms of developing these patents, what is the life cycle of a patent? Let's say a molecule patent. You have a patent and then you have to keep adding to it. How does that work?
So that's a great question. And certainly the answer is there's many different ways of doing this. And I wrote a whole book about how to build these $1 billion patent portfolios, and that's really the crux of what I talk about there. But I think you can have, we know some drugs out there that have over 100 patents on them. We know other drugs that may only have two or three and are just as successful on the market. So it really is not a one size fits all situation. But I can tell you from at least recent years, you probably don't want to just rely on one patent to protect anything. And that is simply because our laws have been changing a lot in the last, 10, 15 years. Ever since I started practicing, actually, a lot of laws have changed quite substantially. And as a result of that, really powerful patents have been invalidated, which, creates a lot of confusion and frustration for those companies that own those patents. So
Yeah.
probably one patent is not enough. So I advise everyone to always think dynamically. You'll get your first starting patent, maybe on the composition, for instance, or on the molecule. And then you have to think about ways to build on that one. Either you find an improvement to your molecule. Make it like if it's an antibody, for instance, if it's better in binding to something, maybe that could be an improvement that you can patent. Next steps is, you want to try one indication. So you want to get patents to protect that indication. Maybe there's another indication that's an option. You want to protect that one. If you're dealing with these biologics, those manufacturing processes, the formulations, the purification processes, all really worthwhile to patent. So you're always kind of thinking about, next steps and just the natural life cycle of this whole drug development process.
Yeah.
Once you get into clinical trials, you're going to have data, you're going to have dosing information, all of that really great stuff to put in those patents and try to, keep building your patent term and keep, making it a little bit harder for somebody to come onto the market.
Yeah. No, I think you've written a lot about this in the textbook, and we'll get to that when Vihang asks his questions. But you've also, as you mentioned, written all of this in your book, which I understand you are upgrading the $1 billion patent book, right?
I was supposed to do that this year, but time.
I know. But thank you for writing the chapter at least. The chapter has been so phenomenal for this book. A quick question on, again, on technology. I mean, with the advent of AI, machine learning, how has that changed, if anything, on the patent process?
So AI is great. I love AI and I love learning about it. It certainly has, it's a brand new field that's only come out in recent years. And with any brand new field, the laws have to really catch up. And what we're seeing with AI, there's still a lot of uncertainty with AI. We know it's probably here to stay. We know it's playing a big role in all sorts of processes, including like drug development and drug discovery. But from the patent side, we are still grappling with some of the basics, like, who's an inventor on one of these AI generated technologies? So that's like one of those fundamental questions, and we really haven't, progressed beyond that. But AI, it opens doors for a lot of things. I personally enjoy working with AI, even if it's just having AI rewrite some of my emails to clients. It makes those emails a little bit better. I love it because it can do some quick research for me very quickly, and so it's that research tool for you. It's having a research assistant that's able to do a week's worth of research within, seconds. So I do think it's opened doors and sped up the process for certain things. But it is a research tool still, and you have to be able to use it accurately. But I think it gives us great opportunities as a patent practitioner or as a lawyer as well, to be able to play around with it and get my job done quicker than I would otherwise. But it also gives, interesting situations on the side of just progressing with patent law, I suppose. And I think eventually you're going to see the laws, whether it's just patent law or just the governmental laws, they're going to have to advance in order to account for these new technologies that are being generated by AI.
Yeah, absolutely. Let me hand it over to Vihang to ask you a few questions.
Yeah, so that's a great insightful discussion, and I really like your take on AI. That you are enjoying the entire process of using AI to improvise on things, drafting emails, and it's a lot of fun thing to do.
Mhm.
So I would like to bring this discussion more towards the chapter that we have written in the book. So could you tell us a little bit about how have you structured this chapter? What should a reader expect when they grab the book and go through this chapter? Could you tell us a little bit about it?
So I always find that people who are not practicing patent attorneys and not in this space, they're often intimidated by intellectual property. When they think about it, they don't really understand what intellectual property is. You hear these terms like terminal disclaimers and all sorts of other sections from the statute that are, put in front of you, and you just don't know what to do with it all, and it's a little bit overwhelming. And so I think my goal with the chapter overall was to simplify what intellectual property is and give people just a very general understanding of the different types of IP that is available to them. Also, of what Narain and I just talked about, like how to build and structure a patent portfolio. So, just, getting people to start thinking about, just the process of what they should be thinking about when they have an invention and they want to progress with it. And then also just to give people a little bit of a taste of what the actual patent prosecution process is with the US Patent Office or with any other patent office out there, and just giving them some advice on how to, structure their applications and put their best foot forward before they try to go ahead and get a patent. So I would say my overall goal was to give people a starting point where they understand the general landscape of what patents are and to give them enough information that they're able to ask the right questions when it's their turn to actually go and try to get a patent.
Great, great. Wonderful. So tell us a little bit about your writing experience. I mean, we just learned right now that you already have another book which elaborates a little more on the patent process. So how was it writing a small chapter versus writing a big book versus your day-to-day business as usual tasks, right? Because I think on a daily basis you're engaging with a lot of clients who want to protect their innovations, and it's more of a rigorous legal technical kind of work versus how does writing feel like when it comes to writing a chapter or when it comes to writing a book. Tell us a bit about that.
So I love writing. I've been doing a lot of writing since I started my career. So I've actually written two books, and I probably need to update both of those books because they're already
Wow.
outdated. So I'm used to writing. I do enjoy writing. I frequently write about, hot topics that we hear about in the news, um, that involve patents, and that's how I've always done it. I think this chapter was a little challenging because there's so much you want to put in there, but you're limited to one chapter. And so I think that was the biggest challenge, is trying to figure out, a good focus to have. Luckily, I did take advantage of having two of my law students from Cornell actually assist with the chapter. So I think that was a great learning experience for them on how to write a chapter for a book. And I think they were quite helpful in putting together not only the original outline, but also just the original draft of everything, which made my job a little bit easier at the end of the day to kind of go through it and to proofread it and to tweak it as necessary. But it was a nice collaborative experience, and it's always nice to get students involved in this process of learning to write because I do think it is an incredibly valuable skill, and it's just opens doors for people.
Amazing, amazing. So finally, what would be your advice for students and young professionals? Just now you mentioned that some of your students assisted you in writing the book. So I'm pretty sure you are also guiding them, supervising them in their journey towards pursuing their careers. So by and large, to any student or to any young professional who's looking forward to intellectual property as a career choice, what is the advice that you would like to give it to them?
Well, right now I'm teaching both of my classes actually. They both fall in this semester, so it makes for a very busy Thursday. In the morning I have my Cornell students, in the evening I have my Penn students. And all these students are incredibly bright students. They're going to the top universities here that we have in the US. And I've gotten this question from them too. It's like, what can we do to actually improve our chances to be seen or to improve our knowledge and all of that. And I think, and this is what I did when I started off, you find interesting topics and you start writing about them because you become a very good expert in different topics because you have to learn about them and then you have to write about them and you have to write about them in such a way that people can actually understand what you're talking about. So, from that perspective, I tell all my students, no matter which direction they want to go into, is to take advantage of those types of situations. Keep learning. There's always something new to learn, especially in patent law. Every day there's a new case that comes out, there's a new issue, and you're not going to be interested in all the issues, of course, but there's a lot of really good issues there, and they are interesting when you look at their fact patterns. So I encourage all of my students to just keep reading and to keep, thinking about those issues. And then ultimately, if they're really interested in something, trying to write either an article or a post for LinkedIn, it could be nice and short. I do have a student this semester who expressed interest in doing this, and now she and I are working on an article about margin rights together. And there's lots of new developments in that space too. So I just tell all my students, you have to be an active learner and you're a constant learner in this field because it's always changing. And so to not shy away from those opportunities, always be learning and always trying to, to give back and, to teach others in the field.
Yeah. Wonderful. Thank you. That was great advice, actually, of writing and for your own experiences. Yeah. So thank you again, Joanna, for spending some time with us and telling us a little bit about intellectual property and also the advice to the students, but so much more in the text in the chapter. So thank you again for
Thank you.
the session. So over to you, Vihan.
Yeah, it's been a wonderful discussion today. Thank you again, Joanna, for joining us for this podcast today. And to all the viewers, thank you so much for tuning in to this episode. Uh, we will be continuing with other episodes with other guests in the coming days. Until then, go grab this book, read through all the chapters, tell us what you think about it, tell us what questions you have, tell us what more you would like to learn about drug development, and we can get this conversation going, learn from these interactions, and keep growing. So we'll see you in the next episode with another guest. Until then, stay curious, stay inspired, and stay tuned to Drug Development Diaries.